Leo V. Diana Esquire of Manchester is next.
Good afternoon, Mr. Chairman.
Good afternoon. How are you?
Well.
Good. If you would raise your right hand for me, do you swear or affirm, as the case may be, that the testimony you will provide before this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do, sir.
Have a seat. If you care to make an opening statement, this is your opportunity to do so.
Thank you. Good afternoon, Chairman Fox, Coleman, Senator Kissel, Representative Rabimbas, and distinguished members of the Judiciary Committee. My name is Leo Vincent Diana. I'm 52 years old. I was born and raised in Manchester, Connecticut, and I've been a lifelong resident there. My wife of 25 years, Tom Lee, is here today with me. She's currently a businesswoman in town. We met in 1975 when we were both students at Bennett Junior High School. Her unqualified love has given me the confidence to achieve my goals, and I would not be here today without her support. We have 4 children. Hillary, my oldest, 23, she's a UConn graduate who's currently attending Southern Connecticut State University pursuing her MBA, and she's also here today. Vincent, an undergraduate at UConn studying environmental sciences. He's at UConn. Emily, an undergraduate at UConn studying physiology, and she's studying for her MCATs. She's here today. Thank you. And Lauren, an 8th grader at Illing Middle School. She's president of her honor society and captain of her cross-country and basketball teams. For 26 years, I've worked in Manchester at my father's small general practice law firm, which is now my firm. My firm employs 12 people, and I have 2 law partners. Being self-employed, I know what it's like to work hard with no guarantees of compensation and carry out the responsibilities of paying your staff and your office bills. Our firm represents hundreds of local people and businesses in the Manchester area. We have very few institutional clients. However, I'm my own boss, and I enjoy the fast pace of a small practice. About a quarter of my time every week is spent dedicating to volunteering in my community or in my practice. For 12 years, I've coached girls basketball. They're between the ages of 8 and 14. I've coached boys football. I've served on various boards, including the board of directors in the town of Manchester. And for the last 2 of my 3 terms in office, I've been the mayor. Manchester has a general manager form of government. My position does not receive a salary or benefits. I spend countless hours every week chairing meetings, attending functions, listening to competing interests. I have input on every aspect of local government, including adopting our annual budget, which we just did 2 nights ago. As a general practice lawyer, my work includes all aspects of the law, including juvenile law, real estate, probate, estate matters, family law, and criminal law. I even was a lemon law commissioner for a few years. Most of my working days are spent in and out of court representing clients or in and out of meetings or conferences. 10 years ago, I formed something I call Manchester Mediation. As a certified divorce mediator, I wanted to help people resolve their issues inexpensively in a calm and peaceful setting. This work has been very successful and now occupies most of my time. I'm also a collaborative divorce attorney, which is another alternative dispute process. I work with other like-minded attorneys outside of court to help people resolve the terms of their divorce cases. This process requires clients and their attorneys to agree not to use the court system to settle their cases. I learned to practice law from my late father. Pardon me. Vincent L. Diana. a 1955 graduate from the University of Chicago Law School. He was a scholar and a gentleman. Everyone respected him. He was a giant in the legal community, and being in his company was very comforting. He had an aura about him. He always said being a lawyer was a profession, not a business, and what he meant that helping someone was more important than money. With good work, the clients and the money would follow. He taught me that life isn't always fair, always do the right thing, and don't be intimidated or bullied by anyone. Being a lawyer, you must have thick skin. He used to say that all the time. I wanted to be exactly like him from when I was a child. On days off from school, he used to take us to court. I'm one of 7 children. I used to love seeing him represent people. He represented the underdog, the little guy, and that was something that I always wanted to do. I wish you were here today to see me in front of this committee. I believe I have the skills necessary to become a judge. I'm very fair, I'm patient, I'm experienced in the law, and I'm accustomed to making reasoned decisions. I'm very humbled by this opportunity to serve the citizens of the state of Connecticut, and if I'm fortunate enough to be confirmed, I'm happy to answer any questions that you might have. Thank you.
Are there questions for Attorney Diana? Senator Kissel.
Thank you very much, Chairman Coleman. Attorney Diana, congratulations.
Thank you, sir.
I know it's must feel terrific to have your family here supporting you in this process. And you probably know one of my very best friends in the world, the mayor of Enfield, Scott Copeland.
I do.
And would it be fair to say that Manchester has the same kind of council, town manager form of government?
Yes, sir.
Okay. When did you apply to be a judge?
2008.
And when did you have your hearing before the Judicial Selection Commission?
2008. The December of 2008, I got a written notice from them in January 2009.
Okay. And so you've been on the list for about 6 years, 5 years?
5+, yeah.
5 years. Okay. Now, have you ever been a guardian ad litem?
Yes, I have.
Okay. And in those instances, about how much did you charge?
My charge varies from $0 to $300 an hour.
Okay. There has been some concern in past public hearings regarding our reforms of the guardian ad litem system, not only this year but in previous years, that on some occasions guardians ad litem charge high fees. It sounds like you have a sliding scale. What would you predicate the sliding scale on?
On what the clients can afford.
And how would you determine what the clients can afford?
Well, I'm usually contacted by 1 or 2 lawyers or by the court. Ask me if I would serve as a guardian ad litem in this case. They ask if it's lawyers, they say, what is your retainer and what is your hourly rate? And we put that in writing. If it's by the court, I get a notice from the court saying you have been appointed guardian ad litem in this case. This is your retainer. This is your hourly rate if you choose to accept it. So you have to notify the court if you want to accept it.
And in any instance where you've been a guardian ad litem, and take a deep breath because I'm not going to attack you, I just have to ask these questions.
Certainly.
And I know I got to be very honest. As much as I've been lucky enough to be here for 22 years, when I propose bills to this very day, if I'm on the other side, even though I know everybody on the committee, I'm still totally uptight and nervous. So I understand it's hard to be on that side as opposed to this side. In those instances where you have been hired first of all, have you ever been just made a guardian ad litem without the parties consenting thereto?
Well, I'm not sure what happens in court when I get a notice, so I don't know. Sometimes I just receive a notice from court saying you've been appointed a guardian ad litem in this case. They go through a list. Most of the other times I'm contacted directly by attorneys, and they ask, we have this situation, are you available? First thing they want to know is, can you jump right into this case? There's a situation, usually it needs some immediate attention, and they want to know if you're available and what your fees are.
Now, one of the sort of questions I had about the system is that while I understand, and you just stated that I have a sliding scale and it depends on what people can afford, but it strikes me that a better system would be that for what services you're providing, there's an adequate charge for those services. In other words, if there's a custody battle between the family that has $60,000 in income versus a custody battle between a family, two family members that have $120,000 of income, it doesn't strike me as necessarily fair that the hourly rate would be double between the $60,000 a year family and the $120,000, because there's got to be some fundamental base services that the guardian ad litem would provide. So could you explain your take on the system and whether you feel that there is sort of a base level of things that a guardian ad litem has to do, no matter what the ability to pay is out there?
Yes, I did look at the bill, and I do think there is reform that is absolutely necessary so that you have a uniform practice. Several lawyers practice a certain way. Other lawyers, I don't know exactly what they do when they act as guardian ad litems. So I believe that they need to certainly speak to both of the parties. They certainly need to speak to the children. A lot of these cases have psychologists involved. Sometimes there's documents, school records, doctors that need to be consulted. So I believe that you need a protocol of what the guardian ad litem's responsibility is. I think it would be helpful to say you have 3 months to do this, whatever you guys decide what this is, but those are some of my suggestions. And then you could say the fee for it is X. And then you have to issue a report, and then if the issues aren't resolved, then you could get reappointed or you would have to go back to court. But I think that there needs to be some more consistency in how the guardians act, because what happens really in cases where you're a guardian ad litem is if you help, and I work out most of the parenting plans that I'm involved in. So when you work out the parenting plan, they might ask you to address another issue in the case. Could you help us resolve the property? Could you help us resolve this? So I don't think that's helpful, because you're not really acting as a guardian ad litem there. You're going beyond what you were initially hired to do. But I think in your bill you can address that, and I think it does address that. So having a standard protocol that every guardian has to follow, I think would go a long way. I think a time limit would go a long way. You could cap the fee, and then if people want to do the work, they can. And if they don't, they don't. People, when my fee changes, they say, and just 3 months ago I got involved in a case, and they called me and said, these people work at this job and they don't have a lot of money. Would you take this case for a reduced retainer and a reduced hourly rate? And in that case, I said, yes, I would.
Have you ever run into a situation where you sent out a bill and the bill was not being paid, where you actually found yourself in court and a judge ordered someone to pay the bill for your services and assessed a certain percentage as sort of a penalty or an interest rate on what's outstanding?
No, I have not.
And was there ever an instance where someone did not pay the bill and they were threatened in court with being incarcerated?
I've not seen anyone be incarcerated over not paying a guardian ad litem bill. If someone hasn't paid my bill and it's brought to the court attention, we usually work out what can be paid on a monthly basis.
You never ever witnessed anybody being potentially threatened with incarceration if they didn't pay a bill?
People file motions for contempt to bring the issue to the court's attention to address the payment of the bill. So I guess theoretically in a motion for contempt, the court has the discretion to find someone contempt, incarcerate someone, but I've never seen anyone incarcerated over not paying a guardian ad litem's bill.
Okay, well then let me rephrase. Have you ever filed a motion for contempt for failure to pay the bill?
Yes.
And how many times would that have happened?
It's not a lot, but I've filed it in the past when people don't like your recommendations and they refuse to pay anything towards the bill.
In that instance, do you actually go to court and would like a judge say to the parties, you better go outside in the hallway and work this out, otherwise there's a potentiality for being incarcerated?
Well, it doesn't work exactly like that, but sometimes just filing the motion gets the conversation going and something is worked out. Sometimes you have to go to court and then you work something out.
Okay, I appreciate that, and you have far more expertise in this particular area than I do as far as practice. You said it doesn't work out exactly like that. Could you sort of describe generically, if the parties find themselves in court, how does it actually sort of play out?
The court system has you have to meet with family relations before you can appear in front of the court to address the issue that's on the docket that day. And when you meet with family relations, it's kind of a negotiation, and they make a recommendation to you as to how you can settle this issue, whatever the issue might be. So many times that resolves the issue. You write up an agreement. You enter the agreement with the court. If you're unable to work out an agreement with family relations, then you go in front of the judge and you ask the judge for whatever relief you're seeking. So if you're seeking a payment on your bill, you say, I'd like some payment on my bill.
Other than the things that you stated about the reform bill, would it be fair to say that you reviewed the bill that we passed out of committee in the last couple of weeks? And would it be your statement this evening that you feel that reform to the guardian ad litem system is appropriate at this time moving forward?
Yes, that would be accurate.
And I know that a lot of folks feel that the bill that is moving through the legislature right now is a good first step. I personally believe it's a good first step. I think there's still some missing pieces of the puzzle, in particular some overarching agency or committee or oversight authority to some group that people can go to. Do you see that there might be an issue if the only place that a party can go if there's a concern about a guardian ad litem is to the presiding judge in their family matter?
So your question is who else would they go to?
Yeah, because the argument is that even though in the bill that we have moving forward, which granted it's imperfect, but at least it's a major move forward, there's also the concern that, well, yeah, I may have rights as a litigant, but if I sort of challenge any decision of the guardian ad litem, I might be on the bad end of whatever decision's coming down the road. So I'm going to be frozen. I'm going to be afraid. I'm going to be very hesitant to raise those issues, even though I can point to a statute and says these are my rights because the guardian ad litem has so much authority regarding decisions going down the road. And let me just take a step back. There was testimony, as well as some of my colleagues have indicated, that in some family matters, especially when custody is an issue, that it's not the judge that is God, it's the guardian ad litem that is God, because, and I use that quote unquote, because they have so much unfettered authority that there's just no one that the guardian ad litem answers to. And I'm just wondering what your perspective is on that.
Yep. The last two times that I was in court making recommendations as a guardian ad litem, one was a relocation case, and the judge did not agree with my recommendation, and I agreed that the children, 2 young children under 10, should relocate with their mom to California because she got a job teaching there. The judge disagreed with that. The other was a parenting plan where the parties lived here, and I had recommended one variation of a shared parenting plan, and the judge decided another variation of a shared parenting plan. So I don't think that the guardian ad litem's decision is God. It carries some weight because it's a neutral party, because you have parents who have opposing views on what should happen, and if you just look at a scale, they're going to either agree with one or the other, or maybe throw out a third option. So I do think a guardian's position can't be ignored, but it isn't the final word. The judge's is.
Okay, I'm going to shift from the guardian ad litem issue because I'm guessing I'll have colleagues that will ask follow-up questions on those areas. You spoke, choked up earlier today. Attorney Avalone talked about his dad being an attorney, and he got choked up, and I got a sense from you that you have big shoes to fill with your father, and having practiced up in north central Connecticut, clearly your family name is highly respected and a storied past. If you could just sort of generally go over you know, the evolution of your practice, what's your practice consist of right now, and, you know, how many people are in the firm. You said you have to meet payroll and all of that. You know, I'm not in private practice right now. I have a single employer, but once upon a time I had, you know, there were 4 partners, 2 associates. It was everything from you're scrambling around doing a title search first thing in the morning to covering short calendar later on in the morning, and then you're doing something else, a deposition in the afternoon, and it's just every day was different, and you know, at the same time you have an eye open to try to bring business in the door, because if you don't have cases and clients, you don't have an ability to meet payroll. So I'm just wondering what you can tell us about what your history of practice has been.
My history has started off doing criminal defense. That's my first passion, and I really enjoyed doing that. Over the years, it moved more towards family. We've always been a small firm. At one time, I had 5 relatives working in our firm. I had a couple aunts, a couple cousins, and of course my dad. And I didn't mean to be choked up, but my dad is the one who, you know, has been kind of my mentor over the years. He passed away a few years ago, and he's, you know, he's not only my dad, he was my next door neighbor.
Being choked up is okay, it's a good thing.
Thank you. And, you know, I was just very proud of him. We had a great relationship, and, you know, I miss him a lot. So our firm has always been very small. My 2 partners, one practices municipal law and civil litigation, one practices estate and business transaction. I do the family and some of the criminal work, and we do all the other stuff in between. And we do. Every day you're in either a different court, or you're at a closing in the afternoon, or I do mediation at night. So I work mediation in between my mayor job at night, or sometimes I do it early in the morning. So every day is different. It's very exciting, but it's very fast-paced. I have 2 secretaries that work with me, and we are flat out all the time.
What prompted you 4 years ago to apply to be a judge, and why this change at this point in your life?
I enjoy being involved in the court, and I enjoy the law. It's been a part of my life for 30 years. I enjoy assessing situations. I've been retained as a private arbitrator on a number of cases for parties over the years, and I enjoy making the decision, doing the assessment, and making a decision. I think I'm very good at it, and I started when I was in law school. In my 2nd year of law school at Western New England, I took a course from Magistrate Egan, and in my 3rd year of law school, I clerked for Magistrate Egan, and he, if you don't know him, he was a prince. He was very calm. He was a lot like my dad. They were the same era. Attorney Avalone spoke about his dad. They're all the same era, those guys. They had a certain a grace about them, and they could calm a situation down. They could make people feel comfortable, and when you take and set up that environment, you bring about better resolutions than the court model. And so that's always been a goal of mine, to kind of follow in the footsteps of Magistrate Egan and become a judge.
What year did you graduate Western New England?
1988.
Okay. So we just missed each other by just a year or so. Well, I congratulate you. I don't really have any issues regarding your demeanor. I think that, you know, you've gone out there, you've knocked on doors, you know, to be a mayor and a council, town manager, form of government is not easy. Manchester's just a hop, skip, and a jump away from Enfield, similar in many ways. Obviously, public service is something extremely important to you, as well as the practice of law is something that you look up to because of the storied past that your dad had pursued. And I give you an awful lot of credit that if you have 5 relatives in the same firm, that's not a, you know, not only are you trying to meet payroll, you're feeding a lot of family members, and if somebody messes up, you're not in a good spot if you got to fire your aunt or something like that. That's not a good thing. So I'm sure that others have questions for you. Appreciate your patience this afternoon going into evening, and assuming that all goes well, which I have no reason to doubt at this time, I think that you have a long and good career on the bench ahead of you. So congratulations.
Thank you, Senator.
Representative Hovey, were you trying to, you seeking the floor? Yeah. Please proceed. And then Representative Gonzalez.
Thank you, Mr. Chairman. Welcome.
Thank you.
And congratulations. You have several children, and so I would like you to tell me what the most profound lesson is that you've learned as a father.
I guess the most profound lesson that I've learned is that you can raise each one of your children the same exact way, use the same rules, and they all grow up differently. And I think that raising children is probably the best thing that I've ever done. I'm very proud of my children. But I think that you need to, if you're going to have children, then you need to make the commitment to put the time in to help them grow and learn. And I felt that I've been able to do that over the years and get involved in their activities and just be a major part of their lives. Thank you.
Representative Gonzalez.
Thank you. And good afternoon.
Good afternoon.
And congratulations.
Thank you.
Okay. Can you tell me around what kind of percent of guardians and Litems and AMC work you in your office a year?
It's about 10% of my practice.
10%? I'm going to tell you, and I'm going to remind you, you're here under oath, and I have here all of it. So I got cases that you, guardian ad litem, and the AMCs, you and your office, how much you charge. So I'm just letting you know, because you're under oath. Okay.
Yes, ma'am.
Okay, let's go. Again, I'm going to ask you the same question. What the percentage of your practice was dedicated to guardians ad litem and the AMC work?
Well, my practice is, I do family law, so I am in family court a lot, but guardian ad litem is not, the bulk of my work is mediation now that I do. It's not in court. So to say an exact percentage, it's a smaller part of my practice. It's not that I don't do it. I have a big practice. I have a high volume of cases. So it's hard for me to, if you want an exact number, I'm not comfortable giving you an exact number.
And I can tell you that I got this and I can do better than that, because I think I got more in my office. So,
well, I do represent children in cases when their parents are in conflict at the request of lawyers, yes.
So you have, right now it's a big percent of your work. What has been what do you charge for hour? And again,
my average hourly rate, my regular hourly rate is $300 an hour.
Okay. And I think that Senator Kissel asked you a question before about that, and I don't think that it was a straight answer. Now we're getting a little bit there, $300 an hour. At the end of a case, let's say that you have a case, and you start with that case. At the end of that case, what about around how much you get for one case?
It's very hard to say. Every case is different. Okay.
Every case is different.
Well, it just depends. If it's an hourly rate and it's $300 an hour, then it's $300 times how many hours that I've spent on the case.
Okay. Okay, I saw a case, and I think that I got it here, not here in my office, but that a judge ordered a parent to pay you. You charge a certain amount of money. And then on top of that, the judge ordered the parent to pay 10% interest if they didn't pay your bill a certain time. Now, that means that if the bill was $10,000, $20,000, or maybe more, and the parent didn't have the money, but the judge ordered 10% interest on top of how much, whatever you charge. If you think that doing that to a parent, that the guardians ad litems are milking them down to the last quarter, do you think that that's in the best interest of the child? I would like to know, and I would like to know from you, how you define the best interest of the child.
The best interest of the child is a combination of several things. First, when you take a case, and this is probably the most difficult work that I do, because parents are in conflict. Many times they don't even communicate with each other. You have to look at what the parenting plan has been when they were a family unit. You have to look at what each parent is trying to accomplish and what parenting plan they're looking for. You have to look at the needs of the child, the age of the child, and depending on the age of the child, if the child has a preference or not. So it's a whole combination. Usually in cases where you're appointed guardian ad litem, there is a specific issue. There's an issue where the child may refuse to go to school. The child may refuse to visit with one of the parents. The child may be having some serious mental health issues, and I've been to the IOL several times. They're usually not just parenting plans. They're usually more complicated and very troubling issues that you have to sort through. So it involves a lot of work. It involves speaking with psychologists. And then after you gather everything together, what I do is sit down with both of the parties and try to work something out. And most of the time I'm successful at doing that. If you're not successful, then you have to have a hearing and you have to make a recommendation to the court.
And when you said mental issue, that maybe some parents or maybe some kids, they got mental issues, do you think that the guardian ad litem have the right to speak on behalf of a mental health provider, or because it's what's going on right now? The GAL, they think that like my colleague here, Senator Kissel said, they're like God. They think they're God, and we have a lot of cases that guardians ad litem are recommending, the parents got a mental issue, or the kid got a mental issue. And I would say, as the GAL, or as an attorney, what right do you guys have as a guardian ad litem to recommend or say the kid has a mental problem or the parents have a mental problem?
I didn't mean the parents. I was talking about the child. And
what right do you have as a guardian ad litem or the AMC to say the kid has a mental issue, mental problem?
Well,
and that's what happened in court. Okay.
I would talk to the child's therapist, and if the child I have a case where a child was pulling her hair out because she didn't want to visit with her dad. So it's trichotillomania. She was a teenager. She would twirl her hair and literally pull her own hair out. She had some mental health issues. I had to speak to her therapist about it and bring it to the court's attention and try to work something out with the parents. But it was a very serious issue, and I'm not trying to supersede any authority of any mental health expert. But sometimes the parents are presenting different pictures to the court. So you have one person saying, oh, the child wants to live with me, and this is the accurate truth. And then you have the other parent saying something that could be totally opposite. So you're just trying to sort through their conflict to bring some type of peace to the child.
Okay, peace to the child. Most of the child they've been deprived from one or from the mother or the father, because the guardians ad litem, that's what they decide. Well, it's not. Mother have a problem, and that's what they are doing. They are taking the parental rights away, and this is what's going on in court, recommended by the guardians ad litem and sometimes with the AMC, and you're doing both. Do you have a malpractice insurance in case of a client were able to take legal action against you for malpractice?
Yes, I have malpractice.
You have one. Okay, so when you acting as a guardian ad litem,
yes,
and AMC, or you representing, a parent in a divorce case,
yes,
how much do you charge? Again, how much do you charge?
In a divorce case, my normal retainer is $4,000, and I bill $300 an hour.
Okay.
However, it varies. That's not every single case. Some cases, I might charge a $5,000 retainer based on the facts of the case. Some cases, I might charge a $2,500. Most of my work now is mediation, where I charge between $2,500 and $3,500 retainers. I bill $300 an hour, or, I can, it's my practice, so I can vary the number if I choose to.
Okay, so okay, but my question is, as a guardian ad litem, as the AMC, and also let's say that you represent a parent as a guardian ad litem or AMC, and you representing another couple for a divorce case, how much do you charge as a guardian ad litem or as the AMC or as a lawyer for a couple?
My standard hourly rate is $300 an hour.
$300.
Yes.
So do you charge the same? So that means that a guardian, as an attorney,
yes,
you charge $300.
Yes, ma'am.
Okay. Now, when you're doing that, if you're charging the same amount, right, for as an AMC and guardian ad litem for
I don't really act as an AMC.
Okay, so guardian ad litem.
Yes.
Okay, $300.
Yes.
So why are you charging $300 when you're working or you're providing service as a guardian ad litem? You're not acting as a lawyer. In that moment, you're acting as a guardian ad litem. So tell me where in the books or whatever it says that acting as a guardian ad litem, you're going to charge the same amount of money that you're charging when you're acting as a lawyer. Just something is wrong, something I don't understand, but something is wrong here as a guardian ad litem, because I'm not a lawyer. I go and I take the training, 30 hours training, and I go and I do my work as a guardian ad litem. I don't have the right to charge the same amount of money that an attorney is going to charge a couple, because I don't have the expertise. Because I didn't went to school for that. I just went to a training, just a simple training for a guardian ad litem. Who gave you the right to charge the same amount of money as a guardian ad litem?
The guardian ad litem fee is based on an arrangement with the parties.
No. If you tell me that it is an agreement between the parties, the most, I would say 98% or maybe more of the parents, they've been here and complain about the fees. They don't know. They just recommend a guardian ad litem. They think that it's going to be the best idea, because they think that the guardian ad litem is going to be neutral, so they go along with it. But guardians ad litems never sit down with the client and never specify the fees, never give them a contract. So right there is guardians ad litems charging thousands and thousands of dollars to all these parents, and that's the problem that we have right now. Thousands and thousands of dollars, and that's the problem. So,
but I think it can be addressed through the bill that you proposed and drafted, and that's why there needs to be a lot more attention, because I hear what you're saying. So if people don't want to hire guardian ad litems at $300 an hour, they shouldn't have to. They can hire guardian at $200 an hour. If you want it, that's more of a policy decision, but I think this issue definitely needs to have a little bit more structure and a little bit more consistency.
Yeah, right now we know that system is broken, is corrupt, and now after so many years that you and your firm make thousands and millions of dollars, well, now we will say, okay, we can go back and say we can fix the system right now, because the system right now, is out of control. We got to come up with a scale. We got to come up with a cap. And you know what? In a way, I will tell you that, yes, that's what we're trying to do. So we can stop the corruption here, because that's what we're trying to do right now. So how can we fix the system?
Well, I think that your proposed bill sets forward some standards that can be put into practice, but in the last 5 years, I think I've had 5 trials that were with regard to guardian ad litem issues in the last 5 years. In my divorce practice, I think I've had like 16 trials in the last 5 years. But I think that there needs to be a consistent policy, and I think that it's worthy of a progressive discussion among members of this General Assembly.
Okay, okay, getting back on the guardian litem, the guardians and litums enjoy immunity.
They don't what?
If they enjoy immunity.
Is that a question?
Yeah, that's a
Do
question.
they enjoy immunity?
Yeah,
They can
guardians
be
and
removed.
litums.
Guardian ad litem's can be removed.
Yeah, that's not a different question. I know right now it's so difficult to be removed because you can come here and say, you know, whatever. We know very clear the guardians and litums are very, very, very difficult to remove because if the guardians and litums and the judges are working together, forget it. There is no way that the guardian ad litem is going to be removed. But that was not my question. My question is about immunity.
I don't know what you mean by that.
Also, guardian ad litem can be sued, or you can't go after a guardian ad litem?
I believe yeah, Carrabba versus Moskowitz. She was a guardian ad litem and she was sued. Yeah.
But right now, as it was very clear that we have a public hearing, and it's very clear that they were saying guardians ad litems, they have immunity, and that's why they are out there crazy, charging all these, crazy fees because of immunity. Now,
I think, but in most cases, I think that the guardian ad litems help resolve the issue that's in dispute. There's not a lot of cases with guardian ad litems that go to trial. Many of the cases are resolved because you have a family that's in conflict and that the child is sometimes lost in the shuffle. If the system doesn't provide for guardian ad litems and you and your wisdom decide that that's not a good system, then I think that family relations needs to be funded so that they can step in. Because when I started practicing back in 1988, family relations wasn't able to meet the immediate needs because you have certain situations that need somebody to step in immediately. So I think that maybe family relations is a system that already works on cases. Many of them are therapists and they have master's degrees, and they're well suited to help address this problem. But I think there needs to be a lot more of them. If you're going to do away with guardian ad litems, you need to have someone protecting the interests of children in these small percentage of cases which are so conflicted.
right, and that's why most of the time the court appoint at AMC, that's the attorney for the minor child. The guardian is supposed to be the eyes and the ears of the court. Now, they're supposed to go out there and do the job and do the investigation and come up with a recommendation.
Yes.
The guardian ad litem is not supposed to be in court when they're going to, hearing. The judge and the judge at that time, he got his ears and the eyes. He don't need the guardian ad litem in court. So and this is why all this bill for time in court and all of this, and this is what we're trying to stop.
I think that's a good idea. I think that the guardian ad litem should be released from a lot of the court work. And there's many times that when there's a trial, the guardian ad litem is directed to testify at the very end of the trial. So you might have to sit through 2 days of testimony as a guardian ad litem to hear information before you get to testify. I've been involved in a number of cases where the lawyers ask the judge, and it's up to the judge's discretion. So maybe in your bill that would be something considered, to say that the guardian ad litem can issue a report, file it with the court, and if they need the guardian ad litem comes. The guardian ad litem shouldn't have to be waiting around in court. The guardian ad litem should take an oath. I mean, I have several things that I think that really could do to improve the guardian ad litem system, but I do think it's a function that's very necessary when you have, these high conflict divorce cases with children that are, sometimes the issue is the children. I mean, I have several cases where the child refuses to visit with one of the parents, and that's one of the issues.
As a guardian ad litem, do you think that you have the right to recommend therapists, parenting classes, and when the guardian ad litem is in that path, recommending all this consultant, all these therapists, and all these doctors, is a 300, like when they recommend a therapist, an evaluation is $15,000. So this is $15,000 that you guys are giving to a friend, and then when you come back to court, they don't use their evaluation. And here, motion to this, motion to that in your case. So how are you going to be out there recommending all these people when these parents, they hardly got money, they're almost broke, but they have to go with whatever you guys decide, a therapist, a consultant that provide whatever. And at the same time, whatever you send this parent to a doctor, most of the time they don't want to accept the medical, they have benefit, health plan. They don't want to accept it because they want cash. And here is the proof. It's a lot of things that I did my homework and I did check. You got well, you don't have the position yet, but you got appointed for this and recommended for this. And I think that you know that all this was going on here in Connecticut about the guardians and items. And you know that a lot of business, you're getting a lot of business, my friend, here for guardian items.
Most of my business is mediation work.
Mediation, you said that you start mediation not too long ago, but guardians and items been for years here.
10 years ago I started mediation, and the reason I started mediation is because I didn't think that the court model worked for a lot of families. I'm a collaborative divorce lawyer. My focus is to take families' disputes outside of court, to not have the court, because I don't think the court is capable of handling many of these disputes. You pointed out a number of issues, and they're all real. Money is the #1 issue. But the most important thing in a divorce case is the custody. If there's a dispute regarding custody, how is it going to be resolved? And mediation calms the situation down, and that's why it's a better environment. I think that the courts, when you go in to try to work things out, is more toxic. But if you can take someone out of the court and bring them into an office and use terms that are calming, peaceful, and try to give them the options, you get a much better result. And so that's why I choose to do mediation. I don't make a lot of money at mediation. I don't make a lot of money.
Well, not mediation, but maybe got in later. But anyway, let's go with this. So you said that you're a mediator, right?
Yes, ma'am.
Do you go to Boston mediation? I think it's a company that authorized by the court in Boston.
No. Boston?
Mediation services, that they said that you violate ethics in making recommendation to the court. And I got this here.
I've never been to Boston.
Okay. And also, it's another case about, I think it was Peter Simonik.
Yes.
Okay. And one of the things that he was saying that he found copies of a check from 2009 and 2011 where payment made by a lawyer and the ex, and a judge order after his litigation settlement check, which you divide illegally years after the divorce. He said, never held the check in my hands. So, you see, I'm doing my homework.
I represented Mr. Simonik's ex-wife. He owed her a considerable amount of money based on their 2008 divorce. I did not represent her in the divorce case. Yeah, I filed a motion for contempt against Mr. Simonik. We reached a written agreement that was approved by the court, and that's what you're referring to.
I got in here. It's just not that I'm making all these things. Do you ever check or do you ever refer in one of your cases the 16 factors of the best interest in the child? You go by that when you are acting as a guardian ad litem or AMC? Do you go by those 16 factors?
Yes, I follow the law.
Follow the law?
Yes, ma'am.
Before I ask you, and you didn't mention the 16 factors. You didn't mention the 16 factors. That's why I came back to the question. It seems like you've been very, very involved with the guardian ad litem. And I don't understand, honestly, why you want to become a judge when you're making all that money as guardian ad litem and the AMC. It's, I don't know if you're looking for a pension or not, but a lawyer that is making all that money, but anyway, it's your choice. And I'll come back with more questions. I will come back with more questions. Thank you.
Thank you.
Representative Buck Taylor, to be followed by Senator Holder Winfield.
Senator.
Thank you, Mr. Chair.
Attorney Diana, congratulations on your nomination.
Thank you.
I have a couple of questions having to do with what you've spoken about and questions that you have on your questionnaire.
Yes.
You said that most of your work now is mediation. How long has mediation been most of your work?
Well, it's probably picked up the last couple of years. I've started just getting a lot more cases.
Okay.
It's always, for the last 10 years I've been doing it, and people call, so we set up appointments. So I think it's picked up a lot because of a lot of things. One is because of the economy, and two is because of the privacy component. And I think after you start in a newer business, which I started at, it picks up momentum and word of mouth, and so that's another reason that the business has picked up.
Now, you do that through the law firm that you work at?
Yes.
Okay. And what percentage of the work that you do at the law firm is your mediation work?
Mediation is, well, it's divorce and mediation, so I would say 40%, something like that.
Okay, you said divorce and mediation, so
Well,
are you lumping them together or just?
Well, it's divorce and mediation.
Okay,
The
it's still mediation, it's not
Yes.
the divorce work. Okay, so that's about 40% of the work that you're doing now?
Yeah.
Okay. And you said in the number of cases that you tried to conclusion in the last 5 years was 21 cases.
Yes.
In tried to conclusion, they were court trials or
Yes,
jury trials?
divorce work is all in front of a judge.
Okay, and when you say tried to conclusion, you were representing one of the parties, not as a guardian ad litem?
Yes, but I think 4 of those were guardian ad litem cases.
So in your practice, you tried 17 divorce cases in the last 5 years?
Well, to full conclusion, yes.
Yeah, okay.
It might be 16. 16 or 17.
Now, when you were referring to the court, and you were talking about your GAL work and things like that, you said that the courts are not capable of handling these disputes, and that the court atmosphere is toxic sometimes to resolving these disputes. When you said that, what went through my mind is, so why does this guy want to become a judge if you think you're getting into a system that's ineffective and toxic?
Well, what I meant by that was for the parties to resolve the case. Courts can decide the issues, but just getting an issue resolved by the court doesn't solve the problem. And I meant to say that mediation addresses the whole issue, and it's a holistic approach at resolving the issue so that the parties aren't back. What happens sometimes at court is people are against each other. It's, a husband versus a wife, and they think that in trials, they think that they have to say bad things about the other party. So if you go through that process, and at the end, then you have to raise a child together, there's going to be a lot of hard feelings and a lot of tension versus how things are worked out. The court system has special masters. The court system has a lot of these alternative dispute processes built right into it. They have family relations that you can go to, and the lawyers can present their cases and try to resolve them with the court system. So I'm saying that having parties against each other and having that environment is just really not the best way. Sometimes it's necessary because some people don't want to agree. They just refuse to agree with one another. And that's unfortunate, but I think that there can be many steps along the way to try to avoid just going to court to have issues decided, because deciding it doesn't necessarily resolve it.
There are a lot of cases in family court where, the family masters is a good system, and we use it in a lot of the courts, and that sometimes helps cases to settle. And we have family services that, again, try to do that. But we just have some cases where there is so much animosity between the two parents that neither of those two outreaches by the courts do any good. If you were a judge and you were presented with that type of a case, what would you do?
I would hear the case. I think one thing that the court needs to do is kind of speed up these issues. They have, sometimes another problem is the delay in getting a hearing. I think that if everything could be moved up a little bit to resolve these issues, but like you said, certain cases, and it's a small percentage, that just need to be tried. And so I would try them, because that's the only way to bring them to conclusion.
At what point would you, as a judge, appoint a guardian ad litem?
That's a good question. I think that, number one, I think if the parents agree that a guardian ad litem is needed, the parents now, not the lawyers, but the parents, then a guardian ad litem should be appointed. But I think if there could be a first step before, like a prerequisite, like a couple sessions of mediation or a couple sessions with family relations before you're eligible to have an appointment, excluding emergencies, to have a guardian ad litem, I think that would be helpful.
What do you believe are the responsibilities and duties of a guardian ad litem?
Well, the term that keeps being used, and it's in the statute, is the best interest of the child, and it's to try to find peace in chaos, and that's really what's going on in the divorce case sometimes, where there's a major issue going on in the household, and it needs to be addressed, and a guardian ad litem needs to try to help the parents see that, and try to find some middle ground, some settlement on their issues, to point out what the alternatives are. I mean, most cases that guardian ad litems are involved in, a majority of them settle. They resolve the dispute. And so I think that my first responsibility as a guardian ad litem is try to identify what the issues are, and then try to come up with some solutions with the parties.
When you're identifying the issues, what do you do as far as investigating? What do you recommend that a guardian ad litem do to properly do their job?
I think the guardian ad litem has to meet with each party. The guardian ad litem has to meet with the child, and then depending on the issue, if there's a psychologist or school or the police or DCF, some of those institutions may be involved, and you need to reach out and contact them. What I do is, after that, I sit down with the parties and try to discuss what my findings are up to that point, and say, this is your opportunity to try to resolve the issues. And so whatever the issue is, we try to kind of brainstorm and come up with alternatives that might resolve the case.
Now, a guardian ad litem is typically appointed in cases where Family Services has an ongoing full custody study?
They can be, yes.
And if Family Services is doing a full custody study, is the guardian ad litem's duty somehow duplicative of what Family Services is also doing?
Yes, they can be.
And do you believe that that is the proper use of the party's money to have those duties duplicated?
No.
So how would you go about remedying that as a judge to make sure that that didn't happen?
Well, unless the parties agreed to a guardian ad litem where there was an extreme situation, I said there should be some threshold, so mediations can be provided through family relations. But if the matter is going to be referred to a guardian ad litem, and I've argued this many times in court successfully, that let family relations get involved and do their investigation, and then if they're unable to bring resolution to the issue, after they've made their written recommendations and the parties know what family relations position is, then get a guardian ad litem if you have to have a guardian ad litem. Sometimes you don't even need a guardian ad litem.
You list in your questionnaire that 100% of your work is in the civil arena. By that, do you mean family?
Yes.
So,
well, criminal also.
Okay, you don't have anything in the criminal. You have 100%
well,
civil.
I don't try any criminal cases anymore, but I do practice in criminal court.
Okay, and what type of criminal work do you do?
Mostly Part B stuff, drunk driving, drugs, domestic violence.
So by Part B, would it be fair to say mostly the misdemeanor type offenses?
GA work, yeah.
Okay. And as far as the non-jury litigation in the last 5 years, all of the cases that you have been involved have been family cases as far as non-jury?
Yes, I've had 2 jury trials in my career, but both more than 5 years ago. I tried them. They were both criminal cases and tried them to conclusion.
Okay. Can you tell me why you listed the 3 cases that you have listed as being the most significant litigated matters, and I'll just ask you whether or not you have a copy?
Yes, I do. Well, the first case that I listed, the criminal matter, was a case that I tried to conclusion. The gentleman had a program, he was available to use the accelerated rehabilitation program, which I urged him to do because he was charged with misdemeanors and we were going to go to trial. He said he did not commit the crime and he wanted to have a trial. So as we sat down to start the trial, the prosecutor substituted the information, showed the prosecutor turned the misdemeanor charges into felony charges, and we had the trial, and he was found not guilty. And he had confidence in me throughout the whole case, and so it was someone who I knew from high school, and it was in the old GA 15 in West Hartford. So it took 2 weeks to try because we could only try the case from 2 o'clock to 5 o'clock every day. So several reasons that's why that case stood out to me.
Okay.
The second case was a divorce case. It was a 14-day divorce trial. It was a case that involved fault. I had the case settled for a very reasonable settlement. I could not convince my client to accept the settlement. After the case went to trial, the difference between the settlement and the judge's order was $1 million. And I was upset, and my client wasn't. He said, you know, he was a physician, and it didn't bother him. He just had such resentment toward his wife. He wouldn't settle the case because he told me he wouldn't give her the satisfaction of an agreement. And I couldn't understand that. So that's why that stood out to me. The third case was very recent. It's a doctor who was dying for stage 4 cancer. She had certain access rights, and it was a holiday that was her holiday assigned. She couldn't drive. Her body was terrible shape. So when I met her in court, her husband wanted to take the holiday, even though it was her holiday, because he wasn't going to take her to temple. She wasn't going to take the child to the temple. And there were a few other issues of that significance. And we argued that in front of the judge. The judge found in our favor, and she told me that she was very pleased with my services and felt that, you know, that she could finally stand up to her husband. She was very frail. She didn't even have a ride home, so she was going to call her friend. I told her no, I'd be happy to give her a ride home. I drove home. We had a very pleasant conversation, and a month later she passed away. So,
My last question. In some of the cases that involve guardian ad litems, the judges have the guardian ad litem testify last with their recommendations, and the theory that's put out there is so that the guardian ad litem will have had the benefit of all the people who have testified, and that the guardian ad litem can then assess or change the recommendation based upon testimony that they heard through the trial. How do you feel about placing the guardian ad litem in that position?
I've been in that position, and I don't think that's, it's never changed my opinion because most of the information coming in I've already been aware of, so nothing usually changes, but so I guess my first impression would be that allow the guardian ad litem to issue a report and testify first.
Thank you. I have nothing further.
Thank you.
Senator Holder Winfield.
Thank you, Mr. Chair. How are you doing? I'm right here.
Hi,
Attorney Diana.
How are you?
I'm doing well.
Sorry, the lights.
So I'm going to ask you a couple of questions to clarify some of what I've heard, because I think I may have either missed or maybe not understood something. So you at one point talked about the court appointing you as a GAL, and I believe you also said that they will tell you sometimes what the fee is. Is that correct?
That is.
And in the instances where they tell you what the fee is, I'm going to assume to some degree they may know you as a GAL and kind of have a sense of what your fee is, and it may be in line with what your fee is. Would that be an incorrect assumption?
Sometimes it is, and sometimes it's just a different number. Mm-hmm. But any time that you get a notice from the court that you've been appointed, they always say subject to your acceptance.
Okay. So in those instances where they give you the fee, do you then go and do a check about how appropriate that fee is? Would you check at that, or would you just either accept or decline?
I would either accept or decline. The fee, the retainer is a deposit. it doesn't mean that that's the whole charge for the case. Sometimes it can be less, and sometimes it can be more. If a case is a protracted litigation, it's always more. When people get involved in high conflict cases, they're in a war. They're at war with each other, and wars are expensive. And I see that that's a serious problem. So, I guess the retainer is what the court orders that's paid, and it's just billed on an hourly basis, and it just depends on what your hourly rate is.
Okay. And then to the question of what your hourly rate is, just so that I'm clear, because at one point you said you spoke about your average hourly rate, and then you spoke about your regular rate, which are not exactly the same thing, but you spoke about them using the same number. So the $300 is what you charge on a regular basis. Now, and that's correct, right?
That's correct.
But you also talked about the possibility of the fee being as low as, you said, $0. Is it accurate to say that most of the time you're closer to the $300? I'm just, for clarity, I'm not trying to beat you up. I know it may feel like that sometimes.
No, it doesn't, but yeah, most of the time my hourly rate is $300. If
Okay.
I'm asked to reduce my rate because the parties can't afford it, then I decide whether I want to do it or not, and most of the times I do. It's $0 because I represented people as a guardian ad litem because they didn't have the funds. I was asked to do it, and I chose to do it.
Okay.
Just very recently, I represented a young girl in the case where her dad was in the convalescent home, and there was an issue regarding access, and I got a call from someone in the clerk's office and said they need a guardian ad litem in this case. There's no money. Would you accept the appointment? Before they even sent out the notice, they asked me. And I said I would. So I went out to the convalescent home. I met with the guy. I met with the child. I met with the mom. I knew what the issue was. We worked out some access, and that was it.
Okay. In your last exchange, I believe that you said if you were the judge and you had a case where you might appoint a guardian ad litem, one of the things you would be looking for in the appointment would be parental agreement. So I wonder, in the cases where you've been appointed, has there always been parental agreement?
No, there's not always been parental agreement. Sometimes one party wants it and the other party doesn't, and then the judge has to decide. But many of the cases probably most of the cases they agree. But I don't speak to the parties initially. I speak to the lawyer. So a lawyer would call me up or write me a letter and say, we've selected you as a guardian ad litem, subject, to your approval. So
Okay.
my first connection isn't always with the parties. It usually is not with the parties.
So you have no way of knowing, initially at least?
I don't know. I just know that in my cases when I'm a divorce, when I'm representing one of the parties and we have a dispute, I talk to my client about whether we need a guardian ad litem or whether we don't need a guardian ad litem.
So I guess that brings me to the next question, because it seems to me like that as you're sitting here, you spoke a little bit, at least in response to questions about things that may be reform needed in the system.
Yes.
And if you have the perspective that as a judge, you believe that parental agreement is a perhaps fundamental part of what should be happening, I assume that you believe that as someone who may be appointed as a GAL, but you have no way of knowing that exists or doesn't exist. So I guess one of my questions is, listening to you talk about reforms, I think one is a good thing, but I wonder, when did it become clear to you that there needed to be reforms in the system?
Well, I guess when I started hearing about all the dispute going on regarding guardian ad litems, it might have been 2 years ago when there started to be a big discussion. And most people have similar protocols, on what they're going to do. Like you said, do they meet with the parties and the children? Yes, most people that I know that are guardian ad litems have similar protocols. I've heard cases through the court and through different mediums that, that the guardian hasn't met with the child, or the guardian didn't spend much time with the parents, or, which shocked me. So I think that there needs to be some standards. So what I did was just looked it up on the internet, and I looked at other laws, and I think one I looked at was Minnesota, another one I looked at was Maine, and I saw some of the protocols and the controls that they have in there, and I think it would be a good thing for Connecticut to have the same thing, to have a lot more consistency in the practice. Because when you don't have a rule of law, then then there's chaos. And there's chaos in the guardian ad litem system right now. Everyone doesn't operate the same way, and that's not fair.
Okay, that's all I needed to know. Thank you.
Representative Rebimbus.
Thank you, Mr. Chairman, and good evening.
Good evening.
Congratulations on your nomination.
Thank you.
And just a few things regarding your application, just for clarification purposes. I did notice that for undergraduate, you've noted 3 different schools, but I think further on in your resume, you indicate that American University was just a semester.
Yes.
But the other 2 schools, did you have to, then you attended 2 undergraduate schools, is that correct?
I did. I started playing football at AIC in Springfield, and then I transferred to UConn in my fall of my junior year. And then in the fall of my senior year, I attended American University for a semester for their justice semester, and I worked in Washington, D.C.
And the transfer school was voluntary? You weren't forced or kicked out of school or anything along those lines?
No, I was a political science major. I really liked AIC, but it was a small school, and I wanted to go to a bigger school, and so I applied to UConn.
Okay. You also have listed collaborative divorce training. I think you alluded to that earlier, I think maybe in your opening statement, or maybe there was a question in that regard, where you had indicated that the parties have to agree not to use the court system. Just to dive a little bit more into that, and I'm not that familiar with the program, although I have heard information regarding the program. If the parties, once they agree that this is the way that they want to go, opposed to hiring individual attorneys and going to court, if they can't agree within this collaborative divorce unit, they are still able to hire individual attorneys and go to court. Is that correct?
That's correct. The difference is that they do have collaborative lawyers. They meet outside of court to address the issues and resolve their case. If either party threatens court or chooses to file a motion and go to court, then not the lawyers that are the collaborative lawyers have, by the agreement, are no longer able to represent the parties. So everyone has an incentive to resolve the case outside of court. So they can always choose to go to court. They're just going to have to basically start all over again and get new lawyers.
And those collaborative lawyers, are each party assigned a collaborative lawyer, or is there one attorney who is attempting to mediate for the parties?
No, each party has their own collaborative lawyer. It's a program that it's similar to mediation, but each lawyer is trained to basically do the opposite of litigation. You try to work out a resolution, identify the issues, bring in experts if you need experts, whether it's you could still have parenting plan issues, so you bring in other people to help address those issues, but you do the whole case outside of court.
And what is your opinion regarding that program?
It's great. It's people who use it, it's very, very successful. I think they use it for a number of reasons. One is privacy, one is cost, and one is it's quicker. So I think it's a great model, and I know a lot of other states have the same thing. It's an international program. I belong to the international organization, and I think it's very, very successful, and it's a good way because it has all the same issues, but they're dealt with in a more of a calm environment. I mean, I go to offices and there's fruit, there's water, there's everything is nice. People sit around. They do have difficult issues, but when you set the environment, it helps get the best outcome. And I didn't mean that court is toxic when I said that before, but that's what I mean, that when you're in the hallways and everyone is upset and angry and you're me against you, that's not the best environment to bring out a resolution.
And I can certainly appreciate that, and actually I was kind of going that way in the sense of, I mean, you have used the words, the court is toxic and the parties are at war, and those are pretty strong words. And again, I'm also an attorney, so I understand that when you talk about people are in the hallways and there's not a nice private quiet room and people are on the clock and they're rushing to get stuff done, or you're waiting around for your case to be called, so there's a lot of other elements that I can understand. Obviously it's not the most conducive environment, but I did want to ask you, when you do use the harsh words of toxic and parties at war, and obviously you're part of this collaborative divorce training. I believe I know the response to this question, but I want to give you the opportunity. Do you believe that if you further are actually appointed to the bench, are you going to have a different perspective or view of any party who decides, no, I want to go to court, I'm going to file in court and I'm going to file my motions, and has an attorney and does not want to participate in this type of a program, or does not want to participate in family services or mediation?
No, no. The parties have a right to have a trial if they choose to have a trial. So I wouldn't penalize them because they didn't choose to use the alternatives, because some cases have to be tried, and I realize that. I just meant to say that there's alternatives. When I first started practicing and using these alternatives, many people would say, oh, I didn't know we could get divorced by working out an agreement. They didn't know. They thought they had to go to court. And they basically just thought that the only way to get a divorce was go have a trial. And so I certainly wouldn't penalize anyone for exercising that right. I just think that people need to understand that there's a lot other alternatives out there.
And I appreciate your response. And I knew and was hoping that that would be your response, but I did want to give you that opportunity. Also, when you talk about your legal employment history, you have since 1988 to the present working at the one named firm, Diana, Conti, and Tanilla. Has it always been that, or has there been different versions of names? I just want clarity in that regard.
When I've been there, that's been the name, but in the past, when it started out, I think in the 60s it was Garrity Walsh and Diana, and at one time it was Diana, Conti, and Camolo, and there have been a few other partners, but I think the majority of the time I've been there, that's been the name. Then the Diana on there it's not me, it's my dad.
Understood. Now, seeing that you're serving currently as mayor of the town of Manchester,
Yes.
What is your anticipation if you do get approved and voted onto the bench?
I would resign my position.
And would that be immediately, or is there a time period that you're going to be providing to Manchester in that regard?
I would do it, I think, relatively quickly after we don't have a meeting coming up for a while. We just finished the budget, so I think we're in good shape.
In number 20, you indicate that there's never been a grievance, that there was a determination of good cause, but you certainly have highlighted to your credit that, or acknowledged to your credit, that there have been complaints filed.
Yes.
Just ballpark figure, do you know how many grievances you may have had filed in the last
7.
5 years?
Oh, in the past 5 years, I think 3.
And just a few more questions. As an attorney, so not as a guardian ad litem on a particular family matter, but as an attorney, have you had a case where a guardian ad litem has been appointed?
Yes.
And in those cases, have you ever found or encountered a guardian ad litem that did not, in your opinion, provide adequate performance?
Yes.
You had testified earlier that you did file a motion for contempt for non-payment of a bill. Correct me if I'm wrong, but my understanding was guardian ad litems were not allowed to file motions. Is there an exception for a motion for contempt?
Guardian ad litems aren't allowed to file, well, I'm not sure aren't allowed. When guardian ad litems do file motions for contempt regarding payment. So I'm not sure if there's an exception to the rule on that, but yes, I've certainly filed motions for contempt on payment.
Other than a motion for contempt as guardian ad litem, when you served as guardian ad litem, did you ever file a motion in court?
As a guardian ad litem?
Correct.
Sometimes you file a motion for advice if there's, an extraordinary situation. So I filed motions for advice from the court.
And I think that's usually either advice or status conference requests and not a formal motion.
And that's the latest thing that you can do now is file for an immediate status conference, and the court will get you on the docket.
Can you give us an example of maybe an experience, whether personal or you've observed, of a bad act by a judge on the bench?
Bad acts by judge?
Yes.
My experience has been temperament, when they've been rude to a client during testimony, when they've been short, when one case I had that it was a custody case and the judge wanted to order alimony when you're not entitled to alimony on a custody action. So I felt that not knowing that was, a bad act, that the court should know that. So those are some of the prime examples.
Well, certainly, congratulations on your nomination, and I, after having heard you here and looking at your experience, I think it's kind of nice that you do have experience in the non-adversarial arena of the courtroom, as well as having that experience. I think if you could take all of that, certainly the positive experiences, the negative experiences, and take that as your, to the bench, I think certainly it would be a good foundation to hopefully be a very effective and fair and good demeanor, and I think that's been tested here today on the bench, so congratulations again.
Thank you.
Senator McLaughlin.
Thank you, Mr. Chairman. Congratulations, Mayor, on your nomination. It's nice to see you have your family with you, and I know they're probably hungry now. You have to feed them, so so is everybody else in the room, I'm sure. I wonder if you believe that the current system for disciplining lawyers is working, and if not, maybe you could share some thoughts on that.
I'm not all that familiar with it, just the grievance process. I do see notices in every court, so I know that people are aware of it. And, I know that the lawyers, when they're grieved, they receive the notice and they have to respond. And so I believe that it's working.
Thank you. And through you, Mr. Chairman, judges in Connecticut do not participate in political activities following their appointment to the bench. Many lawyers are politically active and regularly exercise their First Amendment rights by contributing to political campaigns. In your opinion, is there a point where a lawyer seeking appointment as a judge should disengage from being an active political contributor?
Certainly after they know that they've been nominated, yes. I think that should be a bright line.
And have you made political contributions since 2010?
Yes.
Have you been contacted by political operatives or elected officials seeking political contributions since your approval by the Judicial Selection Commission?
Back in 2009? Yes, certainly.
And have you been contacted by political operatives or elected officials seeking political contributions since notification you were under consideration for this appointment?
When are you talking about then? Consideration since I applied?
No. In other words, you, since notification that you were under consideration for this appointment, you're before us today.
Last month?
I don't know when they did that, sir.
The notice that I've been nominated?
Not the notice. When you were, however it was communicated to you that you were under consideration for this appointment by this administration is the point in time that I'm asking.
So when I was contacted by the administration?
Whenever you were notified that you were under consideration by the administration for this nomination?
Okay. That was, I think, January of this year. So I get emails, I think like many other people in politics, from the national party and the state party all the time. Other than that, no.
Thank you. Best wishes and congratulations to you and your family. I would agree with others who have stated that you seem to have a balance in your experience. I'm hopeful that your experience as a guardian ad litem will be brought forth to help this legislature and the judicial branch in ways to improve that system.
Thank you, sir.
Thank you.
Representative Gonzalez.
Thank you for the second time. Mr. Duran, you are a member of the AFCC?
No, I'm not.
No, not a board member? None?
No, I'm not.
You're not. Has a parent ever, and I heard this question before, but I want to ask you the same question, ever been threatened with contempt to court or jail if they don't pay the guardian litem?
Has a parent been served with a motion for contempt for not paying their guardian ad litem bill? Yes.
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 And put it in jail?
No, not. I've never put anybody in jail for not, I've never asked the court to put anyone in jail for not paying a guardian ad litem bill.
Okay, you're saying you. I'm saying you ever know about...
Have I ever seen it?
No,
I've never seen anyone go to jail for
well,
it.
right now, and I'm not going to say any name, but right now we have here, a parent that went to jail because he didn't pay the guardian ad litem. Okay.
I'm not familiar with it.
Okay, and it happened every day, in every court, it happened every day. But anyway, you say you don't know about it. How many hours pro bono you do every year? You personally, not the firm, but you, pro bono, a year?
Pro bono cases, I take several cases every year pro bono.
Several cases?
Yes, I cited 3 in the application.
And if I call, let's say that if I call OCPD and I ask for the records, that you know, pro bono work?
I've cited 3 cases that I've done pro bono right here in the last year.
Okay, 3 cases last year.
Mr. Card was a disabled veteran. I was called by a military disabled veteran group, and I represented him in a custody case in Middletown. Mr. Grable was a guardian ad litem case that I spoke about earlier, and Mr. Lama was an individual who lives in South Windsor. His wife lived in Nepal. They've been separated for 6 years, and he didn't have the funds for my services.
Okay, so okay. Do you believe in equal shared parenting?
Do I believe in shared parenting?
Yeah.
Yes.
So you believe in that?
I think shared parenting is, in many cases, I recommend shared parenting. In many cases that I represent the parties, I advocate for shared parenting.
And do you feel that some guardians ad litems and maybe AMCs, they can abuse the system right now?
I think there's good guardian ad litems and there's bad guardian ad litems, and so yeah.
And I think my colleague, before she asked you a question, and I'm going to ask you the same question again.
Yes.
And what point do you think that the court should appoint a guardian ad litem? At what point?
First of all, there's the emergency situation. So I think that if there's an emergency situation regarding the welfare of the child, then a guardian ad litem should be considered.
Okay.
That's one. Number 2, if the parents agree that they need a guardian ad litem, I think they should be able to have a guardian ad litem. And 3, I think if there's a dispute regarding whether a guardian ad litem should be appointed, then the parties should be required to have a prerequisite. And I was just thinking about what that should be, and that should be either 2 sessions meeting with family relations or 2 sessions meeting with a mediator. But 2 sessions of something trying to work it out before you have to take that step.
We have here a good judge, a good friend.
Yes.
And he said that he believed that the point that they should, at the point that they should appoint a guardian ad litem, at the time that they should, that the best time to appoint a guardian ad litem is after all resources have exhausted according, that after all resources have been exhausted. That's what a good judge, one of the top judges says here in one of the public hearings. He said after they exhaust all the resources. I think that, if I'm not mistaken, I think, I don't want to put, words in his mouth, but I think that what he understood by that is after they check every single issue, how they can resolve the problem, and then at the last point, because I don't think that if a kid is not abused or neglect, I don't think that they need a guardian ad litem. And when I see a case that is being, that a guardian ad litem is dealing with like indigent family, they don't have any money, and you have a guardian ad litem, maybe I don't know, maybe all the guardians ad litems, when they take those cases like that, the retainer is $500. And then after retainer is $50 an hour. But you said that but you see that when it's a poor family, Indian family, with they don't have no resources, why a guardian ad litem get in? And even though those parents, they don't agree, but they come up with a solution like this because it's not a lot of money, it's not a lot of resources. So they get in, a guardian ad litem get in, the family, they don't have hardly money. The state pay the retainer. OCPD is watching for that bill because they don't want to pump up the bill. They want to be sure. But then, what is the difference that that when you have a couple of dollars, they stall the case for years and years and years. When a case in the Indian family, even though they're fighting, they can resolve the problem like this. It's about money.
Well, maybe it is in some cases. I don't see it that way in all cases. I think that the goal is always to bring some resolution. Most people in guardian ad litem's position want to resolve the issue and bring it to conclusion. And I think they're successful in more cases than they're not.
Okay.
The reason that some of these cases continue is because the parents are in conflict and they can't resolve anything.
Well, I can defer, but before I ask you a question about, what's the percent of your cases guardian ad litem, and you said that most of the cases that you're doing right now is mediation. And the list of the website, judicial website, most of the cases is your law firm, guardian ad litem and AMCs.
I don't act as an AMC.
2014.
I don't act as an AMC. I do act as a guardian ad litem.
Huh?
I do act as a divorce lawyer, and I do a lot of mediation.
AMCs and guardian ad litems in 2014, so it's a lot of cases. Anyway, thank you very much.
You're welcome.
Thank you. Are there any additional questions? Well, thank you, Attorney Diana, and congratulations once again on your nomination.
Thank you, Representative Fox. Thank you.
So, moving right along, we have Attorney Stephen Ecker, Esquire of New Haven.